The New York City Commission on Human Rights does not provide legal advice. The views and opinions expressed in this program are those of the individuals and do not necessarily reflect the views or position of the Commission. Enjoy the show.
Hello, New York. Welcome to another episode of Rights Here, Right Now. I am your host, Jose Rios Lua, Chief of Staff at the New York City Commission on Human Rights.
And I'm your co-host, JoAnn Kamuf, Deputy Commissioner of Policy and External Affairs. And this month we'll be talking about disability rights here in New York City.
Disability justice is about more than just ramps and elevators. It's about dignity, access, and equity.
And that is in part because our favorite topic, the New York City Human Rights Law, is about ensuring that people with disabilities have full enjoyment of everything that New York City has to offer. That includes housing, workplaces, and public spaces as well.
That's what we're exploring today. What does the full enjoyment of disability protections look like in New York City right now?
And to answer it, we have a member of my own team at the Commission, Michael Griffin, who's an attorney who spearheads some of our work around disability protections. Welcome, Michael.
Thank you. Happy to be here again.
Michael, you joined us around this time last year to talk about disability rights. The conversation hasn't gotten any less urgent, and we're excited to dig a little deeper. What values are at the heart of how our city approaches disability justice, and how do we see that reflected in the New York City Human Rights Law?
The whole design of the New York City Human Rights Law around disability protections shows the values that you mentioned. The law itself really envisions treating people the same, regardless of their protected categories, and making sure that they are able to equitably live, work, and thrive in the 5 boroughs. The most visible way that shows up in the law itself is the reasonable accommodation provision, and the part of that process called the cooperative dialogue, which really puts an onus on employers, on places of public accommodation, on housing providers, and also on individuals to engage with each other in good faith to really understand the individual's needs and the way in which the covered entity can work with the individual to enable them to enjoy the right in question.
So some of the things you mentioned bring the words equity and cooperation into mind. And it just makes me think, how does that show up in the actual process of requesting an accommodation? And what should New Yorkers expect? And what does the law require from the other side to make sure it's fair?
Yes, as we've talked about and mentioned a couple of times already, equity and cooperation are at the heart of our disability protections and the reasonable accommodation process. For instance, if somebody realizes that they need an accommodation or knows they might need an accommodation, they are allowed to go to a covered entity, for instance, their employer, and let that employer know, I'm going to need an accommodation. But more than that, there's also an obligation on employers, housing providers, and public accommodations to really engage with the individuals that they employ, that they house, or that are patrons of their public accommodation, to notice if they might need an accommodation to enable them to enjoy equitable access. Furthermore, as you go through the accommodation process, you have to engage in what I mentioned before, the cooperative dialogue, which really requires both sides to engage with one another to really determine what is going to be the best way that that individual can be accommodated, and that the covered entity can do so in a way that's going to be affordable for them or possible for them and not cause them an undue hardship.
So we talk about our law with 3 main jurisdictions in mind, right? And so that cooperative dialogue can come up differently depending on where you're requesting it. So we talk about our law's main jurisdictions as employment, housing, and public accommodations, which just means spaces that are accessible to the public. Are there any differences among them when requesting reasonable accommodations?
There are. I'm glad you brought that up. So first and foremost, the cooperative dialogue is something that's required across all 3 jurisdictions, but there are some different requirements within the cooperative dialogue process and at the end of the cooperative dialogue process especially. All three jurisdictions are required to engage in that cooperative dialogue, to have that conversation, to talk with the person or engage with the person via writing or whatever form of communication is going to work best in the given scenario. But then at the end of the cooperative dialogue, employers and housing providers have to provide a written document summarizing the cooperative dialogue and letting the individual know what accommodations were provided or denied as a result of that cooperative dialogue. And that obligation is not present for public accommodations providers.
What are some examples of what reasonable accommodations could look like? And let's just start off in like the employment context.
Employment can really run a wide array of potential accommodations. I think very often it can show up in the form of changes to policies. For instance, a change to a leave policy to allow somebody to take additional unpaid leave if they need to go to recurring doctor's appointments, schedule flexibility, changes of policy to allow for flexible work. But it can also look like technology or office equipment changes if somebody needs a specific type of chair because they have a disability that affects their lower back, or if somebody needs a standing desk because they need to be able to change position. I think it's important to remember that there's not just one type of disability, and that every type of disability and every way that it manifests can potentially be a reasonable accommodation. So the potential resolutions are just as broad.
In public spaces, what could a reasonable accommodation look like there?
Just for everybody out there, public accommodations can be theaters, they can be your corner store, public transit. Really anything that's not an employer or a housing provider can potentially be a public accommodation. And so, again, I think it really depends on what that public accommodation is and what the person's disability is. But again, it could be changes in policies or exceptions to policies. I think one of the most common that comes up are no pets policies. And if a store wants to have a no pet policy, they should really be upfront and clear that that does not include service animals, because those are not pets.
There's a deli by my house that has a step, so it's hard for anyone who's using mobility scooters or wheelchairs to walk in, but they have a doorbell where someone will come and take your order. And is that an example of what could be some sort of accommodation to help people with disabilities access their services?
Absolutely. Again, I think one of the goals of the cooperative dialogue and the reasonable accommodation process is to encourage creativity. And I think it's also important to remember that while the ultimate goal, I think, as JoAnn mentioned earlier on in the program, is, full and equal access to either a public accommodation or to enjoy the rights in housing, in a situation where an accommodation of that type would cause an undue hardship, to really make it fully equal, that somebody could get over that step and up and down the aisles and with a assisted mobility device, then it's incumbent on the covered entity to really look at what are other alternatives. And it might be a doorbell. It might be to allow somebody the ability to, if they're able to get into the store, because there isn't a step in that case, but the aisles are too narrow, they might be able to come into the lobby and interface with somebody who can go get the groceries for them.
So many of the buildings here were built a very long time ago, and so the width is a challenge. So I think people often think about the front door as the line of accessibility, but again, as you were saying, with the standard in the law, it's really how can someone use and enjoy a service that someone without their disability would be able to enjoy. And one thing about our law is that there is nothing that is inherently considered an unreasonable accommodation. So we start with what is the need and limitation of a person seeking an accommodation, and that's the beginning of the dialogue. Ultimately, if what they need cannot be accomplished because it is costly or architecturally infeasible, then we put our creative hats on and think about what would be possible.
And so wrapping this up with housing, right? There's one thing that sets our law aside from the state's law in housing when it comes to providing reasonable accommodations.
Yeah, I think this is a great flag, and I will just say that this is also true for public accommodations and in employment, but in housing as well. And this is an area where the city human rights law is broader than our state counterpart, is that the covered entity is responsible for the cost of the accommodation. And that means that if somebody's asking for a ramp to be installed, or if they live in an apartment that they rent and they need grab bars, it's the responsibility of the covered entity to not only come up with or listen or engage in a cooperative dialogue about what the accommodation might be and determine what can be provided. It's their obligation to provide the money to complete the accommodation, to really implement it. And in housing, because we have a wide array of housing types in New York City, that cost coverage requirement is very broad, but it does not include the interior of co-op units and condo units that are occupied by the owner.
And then when you say the covered entity, just for anyone listening, you're talking about the landlord or the property manager.
Exactly. The landlord, the property manager, the employer if it's in employment, or the store or the theater if it's in public accommodations.
It's very much like a blanket statement to say you're entitled to a reasonable accommodation, but they do play out differently in all the fields.
Absolutely, yeah.
Who is entitled in New York City to reasonable accommodations? What does that look like under the city human rights law? And how do you evaluate when these provisions apply?
Sure, thank you. I think that's another way in which the New York City human rights law is broader than the federal ADA in terms of what is defined as a disability that's covered by our law. Because unlike the ADA, there isn't a requirement that the condition have a significant impact on a major life function. It's really any condition that causes some diminishment in a person's ability to enjoy the right in question or perform the job functions in question. And so that can look like disabilities that, completely impair somebody's mobility. It can also look like depression. It can look like Lyme disease. It can look like a bunch of things that manifest in ways that are not as outwardly visible, but are just as validly needing of accommodations when that situation arises.
Can you remind us the protections that exist related to service animals?
I think it's important for everybody to really remember that service animals are not pets. Service animals may bring their user, enjoyment. They might bring them companionship, but they are a reasonable accommodation. They are there to serve a specific purpose via tasks that they've been trained to perform that ameliorate the symptoms of an individual's disability and the way it manifests. It could be a seeing eye dog. It could be an animal that's been trained to alert its owner if the owner is about to or displaying symptoms indicating they may experience a panic attack. And so I think it's important for everybody to remember that, service animals in New York City are not just dogs. In terms of the protections, all three jurisdictions that Jose mentioned, housing, employment, and public accommodations, there is a presumption that service animal does not cause an undue hardship. A covered entity is not able to say the fact that you have this animal is an undue hardship, or the fact that the animal would enter my business is an undue hardship. You really have to, because of that specific animal and what's happening with that animal, be able to show that it specifically is causing an undue hardship based on its behavior. And the other thing I would say that I would close on is that when somebody brings a service animal to a place of public accommodation or wants to move in or obtain one after they're a resident someplace or bring one to the office with them, there are two questions that employers are allowed to ask. And those are, is the animal a service animal? And then what task or tasks is the animal trained to perform? They're not allowed to ask about your disability. They're not allowed to ask other questions about the animal. They are not allowed to require paper certificates or documents showing the task or the training. It's those two questions verbally. And if you answer them, they need to let that service animal accompany you into the space.
Does that carry over to public accommodations as well, or are those different circumstances?
No, it's all three. It's housing, employment, and public accommodations.
Yeah, and I think public accommodations are the place where the undue hardship can sometimes show up because there's health codes or rules or regulations that would prohibit, say, having a particular animal in a place where you're preparing food. Follow-up question. Emotional support animals. They're not service animals, but do I have a right to bring one with me to a public accommodation or to my job?
Emotional support animals, again, have a similar presumption in housing specifically to service animals, and that is that they will not cause an undue hardship by the fact that they are present. But to get back to your question, the emotional support animals are not subject to the same presumption that they do not cause an undue hardship that service animals are entitled to under the New York City human rights law. But it's very important to remember that does not mean that a covered entity, a public accommodation provider or an employer, is allowed to presume that they do cause an undue hardship. If somebody requests to bring an emotional support animal, they are still required to engage in that cooperative dialogue to talk through the specifics of that individual's need for the emotional support animal, to consider, as JoAnn said, the specifics of that business. Is it a restaurant? Is it a place that, has lots of, really fragile things like an art gallery? Again, it would really need to be on a case-by-case basis, and that would really need to be something that they talked through. And they would need to, again, consider alternatives.
Yeah, thank you for talking a little bit about the different types of service animals and the different tasks they can do, because I think when most people think about service animals, they just think of like a seeing eye dog, right? A dog to guide the blind. But now we have animals who are trained to do a lot of different things. One of the things that I recently learned about is that there are service animals who are trained to alert when someone's blood sugar is about to tank, or alert when someone is about to have a seizure. Service animals are not a one-size-fits-all explanation, but it also connects to what you were talking about earlier about how disabilities aren't always visible. And so you might see me with a service animal and assume that's my pet because you don't see a physical disability on me, but you don't know I do have a disability or if I don't have a disability. If someone has gone through this and they're turned away from a theater, a restaurant, what is their recourse?
You can come to us. You can come to our law enforcement bureau by contacting InfoLine or going to our website, and you can conduct an intake. You can potentially file a complaint, or if the commission is able to, potentially engage in pre-complaint intervention. You can also leave a tip if it's not something that you're interested in pursuing yourself. You can let the commission know that you experienced this, because the commission can take action on its own.
And for those who don't know how to get a hold of our InfoLine, you can call us by dialing 212-416-0197 or online at nyc.gov/human rights. I think some folks might also think about, well, my disability is not recognized by the ADA, or maybe is not a well-known disability. One thing that folks don't know is that our law is more expansive than the ADA.
It's a great point that, our definition of disability in the New York City human rights law is significantly broader than the definition in the Americans with Disabilities Act. That means that there are a lot of things that are covered in the New York City human rights law that might not be covered by the ADA. And I think it's really important for folks to know that, we have a lot of really well-trained staff on InfoLine and in our law enforcement bureau who are there to listen to what's happened to you, who are there to do so in a way that, while it's neutral, it's still empathetic. It's still going to be really centered around your story and what you've experienced, and seeing how the commission can best respond, if that's filing a complaint or any of the other steps that they might be able to take given the specifics of, what you're bringing to us. But there really isn't a disability that, wouldn't be treated the same as any other, whether the disability is visible or not visible, whether it's something that affects your mobility or your mental health or any of another number of other bodily systems.
And I guess in the sense of, disability advocacy, we should really be saying whether the disability is apparent or not apparent, because as we learn more about disability and as we engage with folks, we just know that people live their lives day to day, and they just want to go through living their life and accessing the services as in an equitable fashion to anybody else.
And I think I just wanted to flag here that we spend a fair amount of time working with other agencies and members of the public, including entities that Michael and Jose have mentioned, employers, housing providers, and business owners, so they understand what the requirements of the law are and that it is more expansive than federal law. I think many, many people have heard of the American with Disabilities Act, and that's important because it was a groundbreaking law, but we're very lucky to live in a city where the law is more expansive and recognizes both a larger spectrum, I think, of disabilities, but also places the onus on covered entities to make their premises accessible to people with disabilities. The increasing reliance on computers, both in the workplace, for housing, and almost every commercial interaction. What does that mean for disability discrimination?
Absolutely. The New York City human rights law covers the internet. Any website that an individual is interacting with in New York, the commission, views that as within our jurisdiction, because this is a New Yorker who's engaging with a service that's being provided that they're accessing in the 5 boroughs. And that means that if you go to a website and you don't find it accessible, you're able to ask that website for a reasonable accommodation. If that website or the business associated with that website doesn't respond or doesn't engage, you can come to the commission and seek to file a complaint. Some of the accommodations that can really make a website, accessible in a way that it truly wasn't before are screen reading technology, are ensuring that websites have an option for, high contrast text so that people with low vision are able to read, the ability to change the magnification level of text so that text can be larger.
And I think one of the ways we have also kind of been thinking about this coming up is the increasing reliance on facial recognition technologies. And this is true, right? Like there are companies that do initial interviews. It's just you're talking to a computer, right? So there might be a threshold accessibility issue along the lines of what Michael just said, but there also is the potential that how you're being scored by a system that's using automated decision making is either taking away points or not giving points if you're someone who does not make eye contact, which could be a person who's neurodiverse. And so I think thinking about all of these things as employers, as just interacting with people is important. Our law tries to be protective of individuals and their privacy, but at the same time places an obligation on employers and housing providers to make reasonable accommodations if the covered entity knows or should have known about a disability.
That was going to be partially my question too. Just like, because I think we hear a lot from in other categories of like, how was I supposed to know? Or I didn't know. And that doesn't preclude you from having someone report discrimination to us just because you didn't know that person had a disability or you didn't know that your website should be fully accessible to the public. Ignorance is not an excuse.
But also trying to comply with the law is not an excuse for being disrespectful.
Yeah.
So
it can be extremely tricky for a covered entity to walk that line, especially if somebody has not come to you and said, I'm living with a disability, I need an accommodation. But just because something is tricky doesn't mean it's not a requirement. It's not an obligation on you as a employer, as a housing provider, as a place of public accommodation to figure out how to engage. And so there are situations where individuals haven't asked for an accommodation, but it may meet that standard that's in our law that you as the covered entity should know that they might need one. That's not to say that you should know they do need one, it's that they might need one. And when that happens, you are required to start that cooperative dialogue. For instance, if there's an employee and you notice that for some reason they're absent a lot more or their productivity is diminishing, it's not necessarily appropriate to go up to them and say, I think you're living with a disability. I think you need an accommodation. I think you need a change to the leave policy. What might be more appropriate is to go up to that individual or to even have a staff meeting for their unit and just say, I just really want to remind everyone that, our company has an extensive reasonable accommodation policy. It's accessible on our intranet. Here are paper copies for everyone. If anybody needs an accommodation, we encourage you to come to us and ask so that we can start that cooperative dialogue and figure out how best to accommodate you given the specifics of your situation. If that individual, doesn't come forward, it might be a situation where, the same message is given to that individual one-on-one, maybe by the EEO officer or human resources. But it's very important that you don't make assumptions because, as JoAnn said, your goal is to comply with our law. Your goal is not to engage in disparate treatment discrimination because you're perceiving somebody as disabled and potentially even harassing them if you do it repeatedly.
Have good policies and communicate them on a regular basis so you're not in a situation where someone said, I have no idea that I could do X, Y, and Z thing at this workplace, right?
Michael, last time you were here, we also talked a little bit about our revisions to the disability legal enforcement guidance. Is there anything you learned through that process about disability protections under us, or anything that like stood out to you?
What really was reaffirmed to me is the breadth of our law, how all-encompassing it is, and really the requirement that everybody involved in a cooperative dialogue be creative, that nobody necessarily be wedded to one specific type of accommodation, because you may have envisioned something, even as the person requesting an accommodation, as what will best work for you. But you might not be aware of the full resources and capabilities of your employer or your housing provider, and they might come up with an accommodation that's not what you initially envisioned, but might actually work better for you. And that's the whole point of the cooperative dialogue, is to really ensure that everybody is cooperating to make sure that individuals with disabilities, find equity in New York City.
Nationally, we've seen some troubling shifts: cuts to Medicaid, rollbacks to federal ADA guidance, and more. And what do these changes mean for the rights of New Yorkers with disabilities? And how does the local law step in when federal protections might be weakening?
It's important for New Yorkers to know that changes to the Americans with Disabilities Act are not changes to the New York City human rights law. If the federal government's enforcement and oversight of the AADA's provisions change, if their guidance is revoked, none of that directly impacts the New York City human rights law. The New York City human rights law is here for New Yorkers. It's been here for New Yorkers for decades. It will continue to be here.
I also wanted to just highlight a recent event that we did, which kind of was an effort in combination with other city agencies to make sure New Yorkers know their protections. And I think the saying that was the mantra of advocates when the ADA was passed, which is nothing about us without us, is something that we take very seriously for all the protected categories. But we work very closely with organizations focused on the rights of persons with disabilities. And we recently held our third ever Disability Unite Festival, bringing together 5,000 people in person, more than 700 people virtually, and we offered trainings and resources in partnership with a number of organizations. I think there were over 50 agencies and organizations who were bringing resources to the table.
What's the biggest misconception or misunderstanding you've faced working in this space?
The first one is an idea that the New York City human rights law is somehow held within or incumbent upon the Americans with Disabilities Act. And I think it's important for folks to understand that just because somebody or something or a resource makes you think that you don't have a claim pursuant to the Americans with Disabilities Act, that does not mean that you don't have a claim under the New York City human rights law. The second thing that I would say is an idea like that the law is static, that the law is just sitting there on paper, and that, it's not accessible. We have an entire agency with different teams and different units that our mission, our reason for being, is to enforce and educate about this law. Our Community Relations Bureau does trainings. We on the policy team have done trainings for lawyers about different provisions of our law. So, we are out here making sure that the New York City human rights law is a living, breathing part of New York City.
Well, Michael, before we let you go, I think JoAnn gets to ask our favorite question.
What is your favorite thing to do in New York City?
I think my favorite thing to do in New York City is to really experience the cultural variety and richness in New York City, to go to different neighborhoods. I live in Flushing, and experience what different parts of New York City really showcase every day, because we have amazing communities from all over this world. And, just by getting on the subway, it's 290, you can go and you can experience something that you didn't even realize existed until you went and you saw it.
Well, Michael, thank you so much for sharing your expertise and insight with us today. And if anyone who's listening wants to learn more about anything Michael has been talking about today, they can find resources on our website at nyc.gov/human rights. Thanks, Michael.
Thank you very much.
JoAnn, I wanted to wrap up our show with a big piece for us, for the agency, that happened last week, and that is our Commissioner and Chair, Anabel Palma, penned an op-ed that was published in AM New York entitled "Fear Should Never Prevent Justice in New York City." And I just want to open up with something she wrote to start off the piece. Right now in New York City, people are afraid. A tenant in Queens is being denied housing because of her race. A transgender woman in Brooklyn is being misgendered and harassed. A young person in Manhattan, whose immigration status is uncertain, is too afraid to speak up after being mistreated at work. They're not alone, and they have protections. But when fear keeps people from reporting discrimination, the promise of civil rights fades away. Powerful words from our commissioner and chair that really kind of highlight the importance of our work every single day.
Part of the essence of this op-ed is in New York City, there's an agency that is here to protect you regardless of your identity and regardless of what changes are being talked about at the federal level. It was heartening to see the op-ed. I think we all feel a great sense of responsibility to carry out the broad mandate of our law, which is dignity for all New Yorkers, regardless of who you are and where you came from.
Yeah, I think the fear is a real tangible thing that people can understand. My experience growing up in Arizona under then Law SB 1070 and having to walk around as a U.S. citizen, as a natural-born citizen, having to walk around with my Social Security card and my passport with me is something that even though you shouldn't need to have, but you still have that fear with you, and that fear follows you. And I think what we're trying to do and what the commissioner has been trying to do is to remind folks that, yes, times are scary, but we're still here. Your rights are still the same. Like, we are still available. Do you want to talk about some of the ways how people can report without saying their name?
Yes, as we said earlier when just talking about disability complaints, but this relates to all the protections under our law: sexual harassment, race discrimination, national origin discrimination, age discrimination, and beyond. You can contact the agency and leave an anonymous tip. Mm-hmm. You can complete a web form on our website with information about the alleged violation. And you don't need to be willing to file a complaint to report that you believe discrimination has occurred.
You don't even have to be the person who experienced the discrimination. Like, you could have seen something and you, in true New York fashion, want to say something.
And there's also the authority the commission has to take those tips and launch its own investigation into something based on either news reports or reports directly to the commission.
And some of the work that you and I have been involved with recently at the commission's been really trying to do is to strengthen those relationships with community-based organizations. Because if you are afraid and there is a community-based organization that you trust, that you can go talk to, we're making connections so that they can bridge the gap as well. I encourage everyone to go and read this op-ed. It's on AM New York. It's linked on all of our social medias. You can find us on Facebook, X, Blue Sky, Instagram, at NYCCHR. The commission is here to help you, whether you feel comfortable calling us at 212-416-0197, or you feel like you need to get some more information on your own through our website, nyc.gov/humanrights, or if you want to request a training.
And many of those trainings are also available in a whole number of languages. If you're making requests and you want it to be in a language other than English, do let us know. I have recently learned we have more than 40 trainings, so there's quite a lot of offerings out there.
Yeah, and as our commissioner has said since January, our human rights law has not changed, and neither has our commitment to enforcing it. All right. Well, folks, that's all we have for you today. Thank you for tuning in to Rights Here, Right Now. Remember that we all must work together to create a city where New Yorkers can live, work, and thrive free from discrimination. Until next time.